Okay, we've hit the top of the hour, so I think we'll go ahead and get started. I'm seeing the attendees kind of level off. So again, appreciate it if you just logged in. This is the Inspection Best Practices webinar that we're hosting by ProLink Solutions and discussing Procorum and some industry topics related to inspections. I am joined here by a number of guests, which I'm very excited about. So I'm Bree Kruder. I'm the EVP of ProLink Solutions. I have Josh Brown here with me. He's the Director of Strategic Initiatives with E&A team and discussing and kind of sharing insight with us today as well. So Josh, I'll let you say hi to everyone.
Hi, everybody. Happy to be here. I am the Director of Strategic Initiatives at E&A team, where I kind of oversee creation of new innovative solutions to challenges in the affordable housing industry that E&A team can help our clients address, and currently oversee all aspects of our operations and our various lines of services and inspections, plan reviews, training, etc. Happy to be here.
Thank you. Chris Bird, Development Director of LDG Development. Hey, Chris. And then Scott Moore, attorney for Baird Holm Law Firm.
Well, thank you. Like Josh, very happy to be here today. I've spent now over a quarter century in the fair housing ADA Section 504 world in all aspects, certainly focusing on fair housing, and happy to be with you today.
Thank you, Scott. Okay.
Hey, I'm sorry, the mute button wasn't working.
There you go. Okay, good.
There's Chris.
By the time we all figure this out, we won't need it anymore, hopefully.
All right, go ahead, Chris.
I'm Chris Bird. I'm the Development Director of the Southeast Region for LDG Development. I've been in the affordable housing industry for, I'm going on my 24th year. I've been with LDG for 8 or 9 years, and overseeing their development in South Carolina, North Carolina, Florida, and I'm also the development manager of Georgia.
Awesome. Thank you. Okay, so we'll go ahead and get started with the presentation. Again, I appreciate you guys joining today. I'm going to start off with just a brief introduction. We have quite a mix of attendees joining us today, some involved with ProLink and closely knows us, some involved with E&A and our other speakers here. So today we're going to be covering inspections. The first area that we'll cover is what requirements apply to my property. That'll be covered by Josh. And then Scott and Chris are kind of sharing that second bullet, the why do I need to be concerned with this from their perspectives. And then Josh is going to round us out with covering how do I ensure I meet these requirements. We are hoping to have some time towards the end for Q&A. I will be kind of gauging the chat and the questions that come up throughout the event so that we can manage to that and address questions throughout the presentation and then hopefully get everything covered by the end. We will also be providing a digest with our follow-up email from this event. We'll have a recording and a digest of the Q&A. So that's another opportunity for us to address anything that might not be covered in the 45 minutes we have right now. Please notice there should be a chat and Q&A feature available to you in Zoom to ask those questions. Please use them. We're monitoring both, and we look forward to hearing from you through the presentation. So don't hold back. Okay, so quick introduction. So ProLink, we provide affordable housing tools for many different constituents in the industry, including our HFA, our state housing agencies. So we provide portfolio management systems for those agencies, as well as systems to support syndicators and investors. We host a number of webinars throughout the year. One primary recurring webinar that we have is for our HFA clients. So we have kind of started to get more and more involved with the development and property management groups through the involvement that we've had with agencies we've been in business for over 20 years working with those agencies. And so naturally, we've found ourselves with opportunities to further support the developer community and the partners of our agencies. And in recent months, we've had a number of opportunities to kind of provide the venue to share more industry news, education resources, and just kind of get conversations started with these other communities involved with our agencies. And so we decided to start this webinar series. You guys are kind of you're the cornerstone. You're the first. Well, this is the first webinar that we've hosted. This will be occurring on a monthly basis going forward, where it's geared towards the partners of our agencies and other constituents in the industry, professionals in the industry that might not, be those authorities or agencies. So we will be continuing to share different topics. We'll have guest speakers that range from maybe clients of ours to guest speakers like we're having today, partnerships in the industry that we have. And then usually you'll see a business presenter. We're mainly covering the business side today with a technical element is typically what you'll see. We are a software provider, so we like that. And then it will last about 45 minutes per session. Again, that audience being for developers and property managers. So we encourage you to continue to register for these and look forward to seeing you there. A little bit more about ProLink. Like I said, we are very much involved with our agency clients. For our HFAs, we have 17 housing finance agencies across the United States that we support with those portfolio management systems, extremely involved in LIHTC. We also support 2 supportive services agencies in California and New York. So again, we also are involved with investors and syndicators, providing portfolio management systems for them. Procorum is kind of the product that we meet our developers and property managers on. So Procorum is a platform that ProLink developed years ago now, when platforms and kind of those portal systems were new and still kind of evolving in just across software in general, but especially the affordable housing industry. And it was really meant to offer a place for secure collaboration between our agencies and their partners. So we would provide these secure centers for collaboration, for task management, to share documents, to go through the origination and application process, all the way through asset management and compliance. It's kind of all done collaboratively on Procorum between our agencies and their partners. And over the years, we've acquired kind of quite a group on Procorum. We have over 1,000 developers represented now. And I think there's a significant number more like active users. I think it's in like the 20,000s, but separately, we have about 1,000 developer firms represented on the platform, logging in regularly to interact with our states. So it's a collaborative portal. It's really purpose built for the affordable housing industry. So it's not something like, you can find a whole bunch of different options out there for platforms and portal systems to collaborate, but this one is truly built for the affordable industry. And we have continued to try to evolve that and make it more useful across the board to everybody. We're not just, it's not just agencies represented on Procorum at this point. So that is what we are aiming to do here. Okay, so with that, I'm going to get over to Josh and let him begin. I know we have a lot to cover in the remaining balance of time. So Josh, I'll hand it off to you.
Awesome. Thank you very much. So the objective today, remember the topic of conversation today is proactive approach to inspections. So I wanted to kind of set the stage here with what exactly are we talking about. We're going to go through the what, why, and how related to what we're talking about in regards to inspections. So E&A team has been doing accessibility evaluations since the early 90s. And so today I wanted to take the opportunity to raise some awareness about the how and what actually applies to your property that you need to be concerned about when you're thinking about having properties inspected, whether they're existing properties for evaluation and in their ongoing period of affordability, or if you're doing a rehab or a construction of a new property. So really what we're talking about are 3 federal laws regarding accessibility. You have the Americans with Disabilities Act, You have Section 504 that comes out of the Rehabilitation Act of 1973, and then you have the Fair Housing Amendments Act. So I'm going to talk briefly about each of those and how they layer and apply to your property. So you can go to the next slide there, Bree. So the ADA specifically covers just the areas in your property that are open to the public, areas of public accommodation. So this is where the public comes to conduct business. So at a multifamily residential rental property, that is going to be your rental office, right? So your rental office is always going to be layered of multiple requirements. ADA is one of them. So it has to be open and available and accessible to the public. Other areas of your property that might also get covered depends on how you use them. So if you have some common areas in your property, for example, a community room or a swimming pool, if you open that up to the public beyond the tenants and their guests of your property, then that becomes a public accommodation, and the ADA would also apply, and the accessibility would have to meet the ADA requirements for that. So the next topic we're going to talk about is Section 504. So Section 504, like I said, comes out of the Rehabilitation Act of 1973. And what it speaks to specifically is that if you are a recipient of any assistance financially from the federal government, then you are required to comply with the requirements of Section 504. And ultimately, what that boils down to is that from a physical accessibility standpoint, 5% of the units in your multifamily dwelling or your multifamily property have to be fully accessible units. These are the units that you commonly see that have the grab bars in the bathrooms, have the larger turning radiuses in the kitchens and bathrooms, etc. Has the front mounted controls on a range, for example. Those are the things that you'll see in a fully accessible unit. So in addition to that 5%, so each agency, HUD or USDA, RD, or sometimes state housing finance agencies all have their own rules about how to comply with this mandate. And so for HUD, for example, in addition to the 5%, they require that you provide an additional 2% of your units, or at least one, for sensory impaired individuals, right? So once you understand how it applies, though, then you need to understand what technical standard actually applies to make those items accessible, right? So these laws that we're talking about tell you what or how many of something needs to be accessible, but the standard, UFAS, for example, the Uniform Federal Accessibility Standard, is what tells you how to make those accessible. It tells you how high that counter is, where that toilet needs to be located in proximity to the adjacent fixtures, where the sink needs to be, how high it is. Those specific technical measurements come out of the standard. And where it can get confusing is that, for example, HUD is the only agency thus far who has deemed an equivalent accessible standard to meet 504 is ADA 2010, whereas UFAS is what the regulation says. You can also use ADA 2010 with a few exceptions. So I say all that to just illustrate that there is complexity in understanding how these apply to your property. So to add a little bit more complexity to it, we'll talk about the next standard, which is the Fair Housing Amendments Act. And so what this applies is where 504 applied to your federal financial assistance being contributed to your property, and ADA applied if you had parts of your property open to the public. The Fair Housing Act applies if your property was built for first occupancy after March 13th, 1991. So that's the first question you have to ask. Is my property, was it built for any purpose for first occupancy on or after March 13th, 1991? If it was, then you know the Fair Housing Amendments Act requirements applies to your property. Then we have to go down another pathway to determine exactly how and to what extent it applies. So on our next slide here, we can look at exactly what we mean by that. So once we've established that the property was built after March 13th, 1991, then we have to figure out what units in my property are actually covered and therefore required to meet the requirements. And it's not every unit. It depends. If there's no elevator in your building, like the example we show here that has walk-ups between the floors, then only the dwelling units that are on the first floor that would be accessed via the accessible route on the first floor via the sidewalk are your covered units. So the other thing is the building has to have at least 4 units to qualify. So if you're talking to someone about what applies to my property, and the first question the first question that they ask you isn't when was it built and how many units is in the building, then you know that they're not really sure about, or they're not familiar with, the Fair Housing Amendments Act. And honestly, the fair housing part is where most people get tripped up, because they don't understand the scope of application of the Fair Housing Act. And oftentimes they think that once I have my 5% for 504, that I've met my obligation, and they don't consider the requirements on the other units. But then let's go to the next slide and let's look at, okay, we've got I missed the spot there, but if there is an elevator in the building, then all your units are actually covered. So I meant to mention that. So if there's no elevator, then it's just the ground floor. But if there's an elevator, which in effect provides an accessible route up through the building to all the units, now every single unit in your property that was built after March 13th, 91 and has 4 or more units are now subject to the design requirements of the Fair Housing Amendments Act. And so understanding that scope is important. And then there's also the ongoing compliance standards just for habitability that we have to look at also. So being proactive in your approach to ensuring that your property is meeting certain habitability standards is just as important. And many of us are familiar with UPCS standard, which is the common standard, the Uniform Physical Condition Standard, that is utilized to assess compliance for properties. And many people know, especially if you're from the HFA world, as I formerly was, that when you're constructing new properties, there are requirements in many of those federal programs that they need to meet the standard at project completion for this habitability standard. And in some programs, it used to be the HQS housing quality standards, and then they transitioned to UPCS. And we've heard a lot of talk about the new standard coming to replace UPCS, Inspire. So obviously, I'm not going to get into the details of those standards. I just want to raise awareness here about there is a need for you to also be proactive in self-assessing your properties in preparation for ongoing compliance requirements, either during development or during the period of affordability, to ensure that you're meeting those habitability standards. So ultimately, that is our what. So now I want to turn it back over to Bree, and we can talk a little bit about the why you should worry about it.
Okay, awesome. So Chris, I think this slide is for you, from the developer's perspective. So make sure that, there we go. I see you went off mute. So the first topic that we have is ongoing compliance obligations for property physical condition.
Yeah, and I appreciate being here today, but first, let me just explain real quick what LDG is and our approach to this, just very, very quickly.
Sure.
LDG primarily does new construction. We are an affordable housing development company. We've been doing affordable housing since 1993, headquartered in Louisville, Kentucky. And most of the markets that we go into, I will say nearly all the markets that we go into, there's a need for new construction and a need for new units to be put on the ground. And preservation and rehab is an essential part of affordable housing in the country today. But there is also a need for new units to come online. And as we're in some of these communities, whether it's a big city like Atlanta or Dallas or Nashville, or smaller jurisdictions, from a new construction standpoint, we are always looking at the overlap between affordability and accessibility. So many of these markets that we're in right now I know a lot of people know the term NOAH, the Nationally Occurring Affordable Housing, which was built before a lot of this that we're talking about, is affordable, but it was built without accessibility in mind. So we're filling that gap. Or we're in a market where you have elevator served buildings that's new construction, and they might be accessible at that level, but they may be unaffordable for people. So from an affordable housing standpoint, from a new construction standpoint, that overlap between affordability, because a lot of persons with disabilities are on fixed incomes, for example, or just have different needs. But we are always cognizant of the fact that affordability and accessibility. overlap in an intimate kind of way. So ongoing compliance obligations for property physical condition. Once our properties, I mean, they always have to stay in compliance with our state agencies, and our state agency here in Georgia is Department of Community Affairs. In South Carolina, it's SC Housing. In North Carolina, it's NCHFA, and Florida, FHFC. But they all have accessibility requirements, and we are required to meet these the ones that Josh just laid out. We are required, obviously, to meet all of those requirements in every state that we're in. Cost of retrofits for accessibility non-compliance. As I just stated, we're mostly a new construction company, but I will tell you, when I see the word retrofit, we're not immune to rework. So Josh stated earlier that we have it's important to have a sort of upfront approach, proactive, I think was the word that he used, approach to accessibility on the front end. Whether it's from a new construction standpoint, it's just imperative that we know what we're doing, that's incorporated into the plans, that our architects and engineers, our civil engineers, all of our we have internal on-site inspectors as well, all of our project managers, because we are an integrated construction company as well. But it's just imperative that we know all of these. What are the requirements? Where does the blocking go? When does it need to be inspected? When I see retrofit, and if I'm talking about rework, is Josh and his team going to come out and see a wall? They need to check the blocking. Is the wall already drywalled? And we didn't call for our inspection in time. So it's very important to stay in lockstep with our inspectors, with groups like E&A, and just get it right, so we don't have to go back and rework this stuff. The word non-compliance as well. I mean, like I just stated, each agency has compliance. We have to stay in compliance. We have to get our 8609 certification, which secures our tax credits. We have to show compliance with all of our accessibility, and that means that from the inspection of the plans and the review of the plans up front before we ever get started in construction, all the way through that last CO, and site and building and unit and common stairs and common areas. We have to show accessibility, that we're meeting that accessibility, and we actually have to have a letter in hand to submit with our 8609 applications in order to be able to secure those tax credits for our investors. So that again, I can't stress it enough. It's just very important to stay up on what your requirements are. Capital needs assessments, including all potential costs. Capital needs assessments, of course, are for mostly, I guess, exclusively for rehab developments or preservation developments. But the message is the same. Like, you got to know what's there. We have done at LDG. We have done in all of our past lives, have done some rehab work and some preservation work a number of years ago, and it's just so important to know what is behind the wall, and really have a plan going in about what the needs are for the community. Are you going to have to regrade between existing buildings for sidewalk accessibility? Where the handrails go? How are you going to block this new bathroom? That kind of thing. So it's really important to have a plan. Necessity for compliance to obtain permanent funding. I think I just touched on that. I got ahead of myself, but that is huge. And it can really hold you up at 8609s when you've got investors breathing down your neck. For credit delivery, you better have been through. You better be able to get the letter. And it's not. And when I say get the letter, I don't mean that we're box checking. I stated up front. At the end of the day, we're all resident-centric folks. We care about the people that are in our developments. We want the best living environment for them, and a lot of our people, a lot of our residents are persons with disabilities or special needs, and we have to be cognizant of that. So the permanent funding is important. Make sure you have the right members on your team. Touched on this also. From plan review, architects, civils. I mean, we go as far as to have on-site meetings and sort of learning sessions, lunch and learn type things with outside of E&A, believe it or not, and they do their own, but to talk about the accessibility requirements. It's so important because, again, going back up a couple of bullet points, the rework kills us. We'll spend $10 up front. If we don't get it right, we're spending $100 on the back end to fix it. So there's that. Ensuring thorough due diligence when purchasing existing properties, and are you buying non-compliance? Again, the capital needs assessment helps you there, but you got to know or lean on those who do. Really lean on those who do know to come and assess your properties for you before you go into a property that may be so out of compliance it might become cost prohibitive, and understand what that tipping point is when you're looking at these properties. Wire inspection is important to us. Everything, all the above. These things can tend to get financially can snowball very, 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 very quickly. We have learned that the hard way years past, but we keep our inspectors close. If we have a question, we call. If there's something in the field that's not quite right, excuse me, or we have an idea maybe about something that meets the requirements that meets ADA accessibility or fair housing accessibility requirements, and we want to do something a little bit differently and feel like it would be a little bit advantageous to do that from a cost perspective, but not sure if it meets compliance, then we know who to go to. For us, it's E&A. There are others out there, but they're very responsive, and just make sure that relationship is cultivated and kept as it should, because we got to keep moving, and we got to keep we also have to think about budget and schedules as well. When do our inspections occur? We consider our first inspection to be during the plan review up front before we ever, sometimes, a lot of times before we close. In Georgia, with DCA, we go through a plan inspection before we ever secure our letter of determination, which secures the tax credits for us, and bonds. So that's our first inspection. We consider that our first inspection. We have a timeline that E&A has given us of when they want to be on site, and it's not like it's not every day, every week, every month. Or we have to come in after framing, and we have to come in to inspect blocking and things like that, and grading to make sure we're kind of hitting the marks on the grades. Of course, we usually get like a 50% inspection, 75, and then a final, and then our final after all of our COs. So they're periodic. They're not cumbersome. I'll say they're not intrusive. They're just extremely important, and extremely important to have them all done correctly, and with a group that you trust and have a relationship with. What actions have you put in place to ensure you're meeting your compliance obligations? Again, pretty much everything that I just touched on. We think that the accessibility, from a cost and scheduling standpoint, is super important. In today's environment, with construction costs the way they are, with supply chains the way they are, with kind of scheduling delays and labor shortages and things like that, it's just paramount to keep this is our perspective, I'm talking about us. It's paramount for us to keep our costs, I can't imagine it's different for anybody else, but our costs in line and our schedule in line. And time today time is money, has never meant more than it does today. If we get into a snowball of we can't get a CO, or we can't get a final letter, a clearance letter from our accessibility compliance compliance group, and we get into this kind of circular thing of we're just kind of hanging out there waiting for something to get done, or we have to rip an entire unit out. You guys know as well as I do, we're leasing up units as fast as we can turn them over. We're never going to build them fast enough to catch up with the need. But if we get into this unit, we can't turn them over. And there are people waiting for the units. We can't secure our funding. We can't, if somebody moves in when we're in there tearing drywall out because we didn't get our blocking checked, it can get really counterproductive, I'll say. We're always going to meet our requirements, and we'll do whatever we have to do it. We have had to tear out sidewalks. We have had to put in ramps and handrails where we didn't think we had to before. We have, we're not perfect, and we do get things wrong. But where we don't get it wrong is we, at the end of the day, we get it right. And we do whatever we have to get it right. Now, the pain getting there is up to us. Are we going to know what we're going to do? Are we going to know how to approach this topic up front? Are we going to know what we need to do and when we need to do it? Are we going to stay close to our inspectors? Are we going to stay close to our attorneys? There's a great one online here. So it's just all of these developer perspective bullet points are relevant and very, very important to take to heart as we're talking through this, because it really, I mean, I'll say it again, at the end of the day, it's about the residents that are living on our properties. It's about the people that we want to provide housing for. It is about affordability and it is about accessibility. And they're the ones that count, and they need to have it done right for them up front. So we're not coming in changing things around them. I mean, you know, these are people's homes, and they need to operate as such. So
Great. Thank you, Chris. That was awesome. Okay, I'll move to Scott's slide. Scott, I think I'm just going to hand this off to you because I know you're going to run with these topics.
You bet. Thanks. And thanks so much, Chris. I think, you know, I couldn't have said it better myself. I mean, I think that, you know, it's very rewarding to me as an attorney for my clients, who are, many of whom are affordable housing providers, that we're all on the same page. You know, we're on the same page of providing the best quality, accessible housing that we can provide, and making sure we do it right. And I will tell you, that is, without exception, my clients are like that. But the reality is these are not building codes. They're not an architectural standard where, you know, we've got to get it right or we don't get a permit, which is part of it. There's also liability exposure here. And that is, these are civil rights laws. They all emanate from either a federal law in the Fair Housing Act in Section 504 in the ADA, or a state or local law that say you cannot discriminate against persons with disabilities. And so ultimately, with regard to compliance or non-compliance, we're trying to get it right, because not only do we have to be concerned about the compliance side of redoing things and retrofitting things and not getting the initial approval, we also have to worry about the back end. And that is, are we going to get a complaint and get embroiled in a administrative charge or litigation, paying legal fees and being exposed to significant damages? Because non-compliance in this context results in a violation of an anti-discrimination statute. So when we talk about accessibility, it's unique with regard to who would file a complaint. There's no question that from time to time, I will be dealing with complaints that are filed by an individual who, you know, their unit or something on the project doesn't provide them the level of accessibility. But I will tell you, more often than not, I'm dealing with complaints brought either by HUD, the Department of Justice, or a fair housing group who has went out there and done testing to find technical non-compliant issues. I settled a case a couple of years ago, and we settled it under a consent order, and the notice period for people to come forward who believe they were discriminated against has lapsed. So we had some money set aside to pay those people. So I sent an email to DOJ and said, okay, well, where's our list of people? Well, we didn't find anybody. No one came forward and said they were denied housing or had difficulty using housing, despite the fact the government brought the case. So understand that many of the cases we see are not based upon complaints driven by one of your tenants, or maybe your tenants are aware of things, but they haven't brought a complaint and they get wrapped in after the fact. Most of the cases are testing and cases we deal with on someone coming out and observing violations, observing these things or seeing these things on your property, and then bringing those claims that way. So technical compliance becomes very, very important. You know, you bring a layperson out to a project and they think it looks great. Look, I see the blue paint. I see those ramps, curb ramps. It's great. But when we really dig deep, we start to see violations of sloping, cross sloping, non-compliant curb ramps, other issues that are out there that really takes an expert to find in that process to make sure we're compliant. Which brings us on the liability side to the next point, indemnification. In this industry, we've relied for years on the agreements we sign with architects, or as architects, the agreements we sign with the developers, or the developers' agreements they sign with the contractor, saying, okay, here's what you're responsible for. You're responsible for the design. I'm responsible for the development and construction. So you're going to indemnify me if your designs are not in compliance. So someone brings a complaint, or if I'm on the other side, right? The designer is going to say, you're going to indemnify me if you don't build to my plans and we get a complaint. You're going to come in and defend it. I'm not going to have to worry about it. Unfortunately, those agreements are unenforceable when someone's bringing a Fair Housing Act claim. So if someone brings a Fair Housing Act claim against the developer and says, well, you know, these were not built correctly, and they name the architect too, and the architect says, look, I got this indemnification clause, my plans were fine, that was a mistake they made, they have to indemnify me. So they file a complaint against the developer and say, you have to indemnify me. Courts over and over again, it says it doesn't matter what your agreement says. Civil rights violations, anti-discrimination statutes don't allow you to do that. So we can't dismiss you from this case. Or have a developer who who only gets sued, right? The plaintiff doesn't bring a claim against the architect. So the developer tries to bring the architect into the lawsuit on their own. Courts have not allowed them to do that because you can't rely on that. So what we've learned is that communication and understanding and all those things that Chris talked about with regard to addressing these issues and putting into place things that protect us during the design and construction process are so important. Because we all have to communicate, because if we touch that project in any way, shape, or form, and that project in the end ends up being non-compliant, we're all going to get dragged into this one way or the other. And we may even be on the hook for responsibility for things that we did not even do in the process because of our inability to bring those indemnification and contribution claims. Also understand that, again, we have the codes, we have the standards, but ultimately, these cases will go to judges and juries and courts to sort of define what we need to do. And I'm going to give you the best example I can of a recent case. There was a recent case out there. It was brought by a fair housing group. It was a conventional apartment complex. And the units were built such that there were 4 or more units, so they were covered by the Fair Housing Act. But each of the units had an attached garage. And there was an accessible route from the attached garage into the apartment unit. It was completely accessible, completely compliant. But the front door to the unit was not on an accessible route. The sloping up to get to those front doors of those units was too steep. And so the Fair Housing Group brought the complaint, and the developer said, look, the technical requirements, the design and construction requirements say that we have to have an accessible building entrance on an accessible route. And we got that. We've got an accessible entrance through the garage. It's on an accessible route. We've met that requirement. And then the Fair Housing Group came back, and the Justice Department filed what's called it's not really an amicus brief, but it's a statement that the department can file in support of the Fair Housing Group. They said, wait a minute, you're right about that, but there's also this requirement for public and common use areas. And what that says is all public and common use areas must be accessible and on an accessible route. And that primary entrance door is considered part of the public and common use areas. After all, right, we use that door, visitors come over and use that door. So that has to be accessible too. And the court agreed with the Fair Housing Group and the Justice Department and held, guess what? Both doors have to be on accessible routes. So that's how these cases come about. And that's why understanding the legal consequences of what's going on here is so important.
Thank you.
And Josh mentioned, I think in the beginning, and maybe not, because Josh and I have been talking a lot about this, so he can mention it at any time to me. But what we are looking at now is offering a legal opinion in these scenarios. Now, we offer legal opinions a lot to, for example, the Georgia DCA, right? So if you're developing a tax credit property and you're receiving tax credits from the Georgia Department of Community Affairs, they have heightened requirements that require certain things for existing senior developments, for example. Even if it was built back in the 50s, there's a requirement that even if you're rehabbing it, you have to rehab everything in there to be compliant with the Fair Housing Act, even though the Fair Housing Act doesn't comply. So obviously that's sometimes impossible or impractical or a fundamental alteration, and it requires a legal opinion from folks like me to get an exemption from that. But what we're talking about is a legal opinion on the front end. After someone like E&A or another inspector comes in and inspects the property and provides a report to you about what needs to be done, we're able to look at it from a legal perspective and say, from our standpoint, in our legal opinion, this is compliant with Section 504, with the Fair Housing Act, with the ADA, to give your lenders, right, your compliance folks, the added level of security, because ultimately, the question is not, did we meet the technical standard? The ultimate issue is, did we meet the requirements of these fair housing laws? And so that becomes a common stream that we need to understand, especially with the complexity of this. Just yesterday, HUD released a notice of proposed rulemaking that they are going to redo the technical standards under Section 504. I welcome you to look that up. We're going to provide an article about that pretty soon because it has a lot of questions that we all need to be responding to from the industry perspective. But we're going to see a whole entirely different set of regulations that are going to be legal based. Mm-hmm. And understanding those and being compliant is very important to get where Chris talked about we want to be. That is, have a great place to live that's fully accessible for all of our tenants. I think we're going to pass it over to Josh again now.
Awesome. Thank you so much. All right, Josh, you have a few minutes.
Right. So we'll do a speed round here to try to kind of bring this home. So I appreciate Scott and Chris kind of setting the stage here. So we talked about what the requirements are. They shared with us from their perspectives why they're important to understand. And now E&A is committed to providing solutions. So I want to give you a how. So how can you actually achieve this? So being proactive is the underlying message here. Prioritize accessibility like it's a building code. Make sure you have the right knowledge on your team and be proactive. The DOJ and NCSHA, as you can see on your screen, both put out back in 2017 and 2018 some recommended best practices on how to achieve this. And we've talked a little bit about those. In your capital needs assessments, make sure you have accessibility included. Get your plans and specs reviewed and have your properties inspected during construction. Train your folks, contractors, job superintendents, everybody but the roofer and the painter can have an impact on accessibility, get them trained. And finally, encouraging everybody on your team to be in compliance. So you can go to the next screen. One of the ways that we have been innovative is in response to what Chris said earlier, time is money. So when you have inspections that need to be done, there's opportunities where we can virtually assist you in clearing items that have been found during inspection so that you can get your subs moving. That's where Insight comes into play. And this is a virtual inspection platform. I encourage you to go to our website, enateam.com, and look more into what that is and reserve an inspection if we can help you. And Insight can be used during construction. It can be used for self-evaluations. It can be used for a variety of things. And it's a fully remote. My inspectors or myself are sitting behind the screen directing your field agent on how to perform that inspection. So you have the E&A team accessibility experts behind the screen there. So you can go to the next screen. So the process that we developed, the how, involves exactly what I talked about from the DOJ and NCSHA, which is reviewing architectural plans. So you sign a contract, we review your plans, then we do what I call risk mitigation, which is the training, and we have a pre-construction conference or attend your existing pre-construction conference so that we can have the conversation so that we can clearly state to your team what requirements apply and why certain decisions were made related to this specific property. Right. And then as you break ground and you start to do construction, we've established milestones at which times you need to bring the inspector in. To Chris's point earlier, we need to see the blocking before you put the sheetrock up. Right. So physical inspection 1 needs to happen at that open wall when you've got all your rough ends completed. And then you can follow this process map on through. And we utilize a combination of physical inspections and virtual inspections where feasible, where a system broad bandwidth can support it. And ultimately, we get through the end and we can give you a letter of certification stating that we saw everything and it is in compliance. The next screen there. So ultimately, you can also, that was for construction and for rehabs, but we can also recommend conducting assessments for existing properties. Federal requirements under Section 504 require you to perform self-assessments of your properties to determine where your non-compliance issues might lie. And you have to revisit those every 3 years in some cases. Also, if you're in the process of purchasing a property, having that property inspected prior to closing, make sure you know what you don't know so that you can do your due diligence so you know what you're buying and what your requirements are. Just because you're buying a property today doesn't mean that you're immune from failure to build it in compliance when it was originally built. So you need to make sure you're fully aware. Insight, it can be used to assist in these things. We can evaluate existing property conditions with you, virtually walk your site, give you some insight into these types of issues, help you determine scope of rehab. We can also use Insight to help perform self-assessments under a UPCS or Inspire-based inspection to help you prep for an HFA inspection or even a REAC inspection to give you an idea if you're meeting the habitability standards or if you are an HFA, we can help you perform your obligations for inspections by using our Insight to virtually inspect a property for those standards as well. So ultimately, I wanted to share with you some final pieces of the puzzle here. This is a view of Insight from the inspector's view. This is what I see behind the desk. The image that you see there with the tape measure is looking through the field agent's phone. I have control. I can zoom in, I can zoom out, I can snap pictures, I can mark up that photo, I can take video. I have full control over what I am capturing during that inspection, and I am communicating via audio with that field agent so that I can make sure that we're getting a thorough inspection. And then on the next slide is the field agent's view. This is what they see. It's just a smartphone, and I need 2 people in the field, one running the smartphone, one running the tape measure or the slope meter. And then they just follow instructions for what I need to see. And I walk through the property with them virtually, and I can capture all of the imagery that I need to document and support a thorough inspection and give you what you need to know, either clear items that were previously found or identify new items that previously weren't inspected, et cetera. So that's just a brief version of how we use Insight as an innovative tool to help keep construction schedules on track and to help our clients meet their obligations. So with that, I'll turn it back to you, Bree.
Thank you, guys. Can you still see the screen? I might have exited my view. Okay. So one thing I wanted to mention is, you know, as a software provider for the agencies, we're seeing more and more of these like kind of handheld inspections on site, kind of virtual inspections happening, and taking in more of that data through those kinds of tools as well on the agency side. So it's definitely something that I think is the new way of doing inspections and something that is wonderfully available to us, right? I mean, in general, it's so nice to be able to do more faster and more frequently, check in more regularly to make sure that we don't hang ourselves up. So I want to thank you guys all for being part of this session. I really appreciate the attendance, everyone sticking around. We're a few minutes over, and I appreciate that. We will be hosting another section towards the end of May. We will be including, let me see here, I just got an update because we had a meeting while I was on this session. But we have some debt and equity providers who are going to be sharing some current market trends in the industry. So that'll be our topic that will be shared towards the end of May. So we'll follow up with a registration link and information with specific topics that we'll cover in that session over the next week or so once that's finalized. So with that, I think I'm going to end the session today. Again, I appreciate everyone for joining us, and we look forward to sharing the next one with you in May. So have a good one. Thank you very much.
Thank you.